It is June 24th of 2026, and this is the Court Gallery. Coming up, things get started with a defendant who was told one thing: show up for your jury trial. Guess what he didn't do? Guess what Judge Middleton does in response? Then, a judge gets a case that's been sitting for a month without any formal charges and decides to teach the prosecutor a powerful lesson about due process that the defendant will definitely appreciate. And we'll end with a man on probation who thinks he's found the one weird trick to beat a breathalyzer test. But Judge Simpson has seen it all before. From flimsy excuses to fascinating legal arguments, all that and more starts right now.
Good morning. Today is the 24th of June. We are here theoretically for a jury trial that isn't going to go. I let everybody know yesterday we would not be having a jury trial today. We're making a special record. This jury case is the only thing I had scheduled for today. I have the even numbered Wednesdays set aside for jury trials on my docket. We had several cases set for this morning. We resolved several of them. One had to be adjourned because of unavailability of a complaining witness, which left us with Mr. Ashton Crum. And we're going to address that here in just a moment. Abby Stoll from the prosecutor's office is here with me, and Mr. Paul Gibson. So this is going to be a very short court morning. Today's first line is another song that everybody that my age owns this record played it once at honors night and made people cry. You only get the first line. I listen to the wind of my soul. Where I'll end up, well, I think only God only knows. Take a listen to that today. It's sort of in the same mode as the last three records that we had. Hello to everybody in Sturgis and Colon, and today is the lobster lunch at the jail, I think. All right, thank you for all saying good morning. Let me get to it, free up Ms. Stoll and Mr. Gibson, and we'll make this special record. Judge Pattison has a very busy docket today, and I offered the use of this room, but he's content to be where he is. I think when I log off, he may end up using this room. Well, let's make a special record in the matter of People versus Ashton James Coon. File number is 251994. It is a 2-5 case. I don't like cases that are that old. That occurred actually more than a year ago. The date of the incident was June 17th, 2025. Mr. Coon was charged operating while intoxicated as a second offense, an open intoxicants in a motor vehicle. This matter was charged under state statute, and the county prosecutor's office has been in charge of the case. Mr. Coon had another drinking driving case, the predecessor to this one, which was in file 241568. One of the reasons this case is so old is because Mr. Coon was off the radar for a few months till we caught up with him again. He was here on a probation violation in May. On May 28th, he pled guilty to a probation violation for impaired driving, and I gave him 11 days jail credit, 11 days. His attorney in that case was Mr. Tim George. Mr. Paul Gibson represents the defendant in this case, which is set for jury trial today. Mr. Kuhn is essentially homeless. He often fails to appear for court. He has some mental health issues. I made a specific referral to Pivotal, our jail health liaison, when he was in custody the last time. I specifically told Mr. Kuhn on May 28th, you have a jury trial set for June 24th. Your lawyer is Mr. Paul Gibson. You need to contact your lawyer and discuss this case with him prior to June 24th. I had contemplated just leaving him in jail. But that would be a long time from May 28th to June 25th to simply leave him in custody. So he was specifically told to contact his attorney as soon as he got out of jail, and told on the record, again, reminded they had a trial date today. As far as I can tell, he did not contact Mr. Gibson, and Mr. Gibson made multiple efforts to try to contact him, and he didn't show up. Mr. Gibson, what can you tell us about this?
Well, it is my understanding that the defendant was residing in his car. So as far as trying to contact him about the court date, I tried to make phone calls or email, sent an email to an email address. If I'm not 100% sure if that email was returned or not, but I have not been able to get in touch with him. I have attempted to, and so I don't know if he forgot about.
Well, as far as you know, he never made any attempt to contact you since May 28th.
Yeah, my notes show I didn't talk to him in May, so I don't believe he tried to contact me.
Well, I think you may have talked to him when he was in custody. That 11 days that he was there, we took a stab at trying to resolve this case as well as the probation violation. He admitted to the probation violation, but did not resolve this case. But anyway, you've had no contact with him since May 28th.
Correct.
We did call off the jurors. We stay in contact regularly regarding the pending jury trials. In fact, Abby and I were just talking about the July 8th jury trials to try to be proactive. We don't want to bring in witnesses that don't need to be coming in on overtime or day off. We don't want to bring in 36 jurors. As it turns out, at least 3 jurors have shown up this morning. Didn't get the message that the case was canceled. And that's an inconvenience. They take the day off. They're nervous about coming to court. They probably didn't sleep well. They show up, find out the case is off because they neglected to call a message to find out it was canceled. But when someone demands a jury trial, it puts a lot of stress on other people. Anyway, Mr. Kuhn clearly knows about today's date because I told him. I told him to contact his lawyer, he did not. I don't know how to reach him. He was not living in his car because his car was impounded. And I don't believe he's living with his parents on Hutchinson Road. So the defendant failed to appear. If we can get a hold of him, maybe we can resolve the matter. As I indicated, the facts in this case are quite strong on behalf of the prosecution. Failed to appear, bench warrant. Set a bond that he can't post, I hope. $10,000. Yes.
I would ask that the court revoke the defendant's bond. It's a condition of his bond that he keeps in contact with his attorney, which he hasn't done. He's asked for a trial, and the court's made it well aware to him that today was the date for trial. This has been an extreme waste of everyone's time and resources. And if he wants to have a trial, I believe the best place that he can be is in jail until he gets his trial.
I seriously contemplated that very thing, just canceling the bond problem. And if he were here, I guess I would have canceled his bond and set the matter for the July 8th jury trial date, which would be within 28 days. He, as a practical matter, he isn't going to be able to post a $10,000 cash or surety bond. It is a 1-year misdemeanor. He's failed to appear on several other occasions. As I indicated, once I get him, I want to hold on to him. If he is taken into custody, theoretically, in a misdemeanor case, he's entitled to bond within 28 days unless good cause is shown. And a PR bond within 28 days unless good cause is shown. And I guess good cause is he doesn't show up for his court proceedings.
I would request if the court would consider a 48-hour hold on any warrant, just
No,
because.
there's no 48-hour hold. He's not here. He brought jurors in. He defied my specific instructions to contact you and call his lawyer. I will grant the prosecutor's request. Bond as revoked. See, Judge, I can set a bond. Once he gets picked up, I can arraign him on the bench warrant and set a bond. But for now, it's no bond. See, Judge. No 48-hour hold. At one time, he was staying in the parking lot adjacent to the courthouse. And I would see him. I don't know where he is, but he isn't here. And as Mrs. Stoll said, he's wasted everybody's time. This case has been dragged on for a year. I believe it's previously been set for jury trial. We don't wait our cases a year to go to trial on a drunk driving case. I had hoped we could resolve it when we had the probation violation, but we weren't able to. So bench warrant, no bond, see judge, no 48-hour hold. Do not pass go, do not collect $200. Stephen Campbell is the case we had to adjourn. Prosecutors made a motion to join, which apparently the defendant accepts, and the complaining witness isn't available. So we'll try to find a place to put that. Because this wasn't scheduled, none of the stuff is in my queue. I didn't have the files. Prosecutor's not notified. Public defender's not here. So we just kind of start from scratch. All right, this is in the matter of People versus Davion Coates. That's you, sir?
Yes, sir.
Here with your lawyer, Mr. Luke Knopfsinger. This matter was set for sentencing on Monday, I believe the day was. I was here, your lawyer was here, the prosecutor was here, the bailiff was here, the public defender was here, and you weren't. I think I I don't know if I tried to call your number. I'd given you a handwritten notice from me to you with the June 22nd at 10:30.
Yes, ma'am. I mean, sir. I was at the courthouse in Three Rivers at the time. I went there at 8 and I asked them, is this everything? And they told me, yeah, but I thought I was supposed to be here on the 26th, which is this Friday. So it's my mistake, honestly. I'm sorry.
Well,
I should have reread the paper.
So did you have court in Three Rivers?
For my court fees, I had to go to court Monday.
Oh, for circuit court?
I believe so.
Yeah, I believe it's a show cause.
It's an insult to me. And as I said, it's a nuisance. We're all here cooling our heels, waiting for you to show up. This is a case of some import. You were charged with resisting and obstructing a police officer. It was reduced to an attempted resisting and obstructing a police officer. I told you I'd watch the videos of the incident. I had a little trouble getting them, but I got them. And I watched them, and it was troubling to me. So I had prepared to do the sentence, prepared to hear from you, prepared to hear from the prosecutor. So apparently you were in another courthouse. And I'm not going to do it now. The prosecutor's not here. One option is just lock you up, cancel your bond. You're not presumed to be innocent. You've entered a plea of guilty, and hold on to you until such time as I can do the sentence. So if I'm going to go on vacation at some point in July, and you'd be sitting there until about the 1st of August.
Judge, a couple things, if I
Yes.
may. Mr. Coates called me this morning and said, I missed my hearing on Monday and I see I may have a warrant. We then got here as soon as we could. I think it was an oversight on his part. It was a surprise he didn't appear on Monday. We had contact the week before, and he found out that he missed the hearing and he contacted me immediately. A friend had watched apparently the YouTube stream and said, "Hey, Davion, you missed your hearing." So he took action.
Well, we joked about, I do appreciate it. I say, if anybody's watching this, they know Davion Coates, tell them to go get in here. And very often that happens. A relative or somebody will call and say, "Hey man, you missed a court date." But I gave you that thing. I said, put it on your refrigerator. You also have some unpaid fines. In a previous traffic case. I gave you, I guess, until the 30th of June to pay that, and it's not June 30th yet. So now, as I said, I don't really want to leave you in jail till August. Defendant was in court in Three Rivers. Now I got to figure out where to put it. As I indicated, there's a video of this, and the video is troubling to me. We've had several of these lately. Are you available on Wednesday, July 29th at 10?
Yeah. You talking to me, sir?
Your attorney.
I'm sorry. I apologize.
That's all right. Well, are you? Do you have a doctor's appointment or something on that?
No, sir. I'm available.
Judge, I was joking about no day off. I'm taking that day off.
All right. Well, no one ever gets a day off. There's how about Monday, July 27th, 10:30.
Yes.
All right. I'm going to ask the bailiff to take you out to get a formal notice. I gave you a handwritten notice in my scrawly handwriting, and that apparently wasn't good enough. You have strong feelings about this. The prosecutor may have feelings about this as well. You could go to jail for up to a year for this. A felony reduced to a misdemeanor. You got unpaid fines and some traffic matters. I want you to treat this with more urgency than I forgot to show up. That was Monday. It's now Wednesday. You never bothered to call your lawyer till somebody called you, and I give Luke a A+. He dropped what he was doing and came over here to represent your interests. So it's a damn nuisance when you don't show up when you're supposed to, for the bailiff, for me, for the clerks, for the public defender, for the prosecutor.
I apologize, Judge.
All right, we'll address it further on Monday, July 27th. I'm going to give you a formal notice. I want you to pay on that other thing before I see you next time.
Yes, sir.
This is docket 256739 FH People's State of Michigan versus Urban Berkeley. Counsel, your appearance for the record.
Thank you, Your Honor. Randall Burton on behalf of the people. Good morning, Your Honor. Robert Easton on behalf of the defendant, Mr. Berkeley, who is present standing to my right.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, one truth, and nothing but the truth under penalty of perjury?
Sure.
Thank you. Raise your hand down. And sir, you taking any medication yesterday or today?
And you have to take medication advance for colitis. It's called Middleton.
I don't even need to know what it is. I don't want to interfere with your privacy here. I just need to know if it's anything that would interfere in your ability to understand your attorney to report.
No.
Counsel, do you believe he's oriented to date, time, and place, and does understand everything?
I do, Your Honor.
All right, seems like he's very alert today. And sir, is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
You had no time to talk with your attorney?
Yes.
And have you reviewed the pre-sentence investigation report with him as well?
Yes, Your Honor.
All right, thank you. Any corrections, additions, deletions on behalf of the people?
No, Your Honor.
On behalf of defendant?
Yes, Judge, I would point out just a couple of things. On page 1 of the pre-sentence investigation report, it indicates education level at 9th grade. Mr. Bertley has completed a GED.
Good, and I'll change that to GED, that we have the cover page, and then in the inside, is it correct or not?
And then it is addressed on the inside. We can provide verification if the court requires that. Because it just says on page 1 that it's not verified, so we can provide that as well.
All right,
The only other thing I would point out, Judge, is on page 2 under the description of offense narrative. And it does reference the incident report, but then there is a summary on page 3 that indicates total amount that was seized from the residence. And the court may be familiar with the forfeiture action that was before the court in reporting another party. The only amount that was present in the house was the $1,000 in his pocket, which is on bullet point number 1. And then the approximately $12,000 that was in his bedroom. The remainder was recovered from the vehicle off of the premises that did not belong to him, and was not registered to him, was not on the premises or the curtilage, and belonged to a different party.
so this indicates on page 2, the $1,022, that is what was in his pocket.
That was in his pocket. It was in a pants pocket of his, and then the $12,000 that was located in the bedroom.
In the pillowcase. Okay, so then we also have $205 in a gray sweater. That was not his.
That was his as well.
Okay, and then we also have a black safe of $50,000.
That was what was in the vehicle that was off of the property.
Was that vehicle his?
No, we didn't.
So do you want me to put in a vehicle on his? Was it related to this case? How?
It is our position that it's not related to this case.
On behalf of the people?
You can note that it was located in a vehicle. I have no objection to that.
So I'm going to put located in a vehicle that was not defendant's?
That's correct.
That's true.
Okay, so I noted that. What about one heat sealed bag containing $50,000? Is that the 50 that was in the black safe?
I believe so, Judge.
Yes.
That same note can go to the 50,
Okay.
the 50, and the 51, and the 10. And then under that, it's just one black safe vehicle location, so it is noted somewhat, but not very clear.
So that also goes, you said, to the $10,000 in the black safe? Is that a different safe or the same safe?
Should all be the same.
Should all be the same, Judge.
It's just not very clear how they wrote it, so I'm just adding these notes. Would that also be true of the money counter, the electronic scale, the baggies located in the rafters, the digital scale? Who belonged? Does that all belong?
Those things were all present in the residence, Judge.
Okay, so these were found in the residence. in defendant's residence?
Yes, Judge.
So then it goes on to say a total of $127,227 was seized, but it appears that only a portion of that was defendant's. Would you like me to include that? Do you know how much was attributed to defendant?
That would be the $1,022 in the right pocket of the defendant, the $12,000 in currency
And the 205.
and the 205.
So I'm putting of which 1,022, 12,000, and 205 were defendants.
That's right.
I think that's needed for clarity given the above. All right. Any other corrections?
Not for the defense, Judge.
And what about the guidelines?
I had no challenges or corrections, Your Honor.
Thank you.
Defense as well, Judge.
All right. And on behalf of the people, what would you like me to know?
I have no comment. Thank you, Your Honor.
Thank you. Counsel?
Thank you, Judge. I've had an opportunity to spend some time with Mr. Bartley over the last couple of months. He's fully accepted responsibility here, recognizes that this is not who he wants to be, where he wants to be in life, as is indicated in the PSI. He's got some young people that he is responsible for.
Well, he had those young people when he did all this too. So that does not faze me one bit, counsel. I appreciate your mentioning it. But that all should be considered before criminal activity.
I agree, Judge, and I think, and my point is that he now understands that in a different way. He's had obviously some trouble in the past, and to find himself in a situation like this in front of the court now, and to have to share with his family that he is, again, risked his opportunity to be there and to be supportive of them, has been, I think, a maturing moment for him in the last few months. I think he is motivated to ensure that he is not engaged in any conduct that would risk his future or with his children in the future. He's also been working pretty steadily for about the last 4 years. Has maintained active employment.
Is this with Sir Pizza or somewhere else?
This was Sir Pizza.
You support a family on Sir Pizza?
Excuse me,
Are you able to support a family on Sir Pizza?
not really. I don't really do much. I'm only on child support for 2 of my kids. They take it right out on my check. So
Anything else, counsel?
At this time, Judge, I would just ask that the court would follow the guilt agreement.
Sir, what would you like me to know? This is about you. What would you like me to know? What do you think I ought to do? What changes have you made? What have you learned? I mean, there's no easy money, sir. There's no putting drugs in our community. You've got, let me see, 2 children. Are they twins? 16?
no, they're not twins.
Okay, two different baby mama?
Yeah.
Yeah, okay. And then you got 2 16-year-olds, you got a 15-year-old and a 13-year-old. They are of the tender ages where someone like you is going to sell them drugs. Is that what you want?
Yeah.
Well, then why are you doing it to the rest of us?
Oh, excuse me.
There is no excuse. Every single day in this community, somebody dies. A child dies of gunshots and illegal drugs. And all our children are related. So it hurts my heart when somebody else's child dies because it could be mine, it could be yours. And what I read here, you didn't give a crap about that. You cared about the money. And you're not making enough at Sir Pizza. So what's going to change there?
But I've been looking for a second job as well.
Oh, sir, you've been looking how hard you've been looking, because I gotta say, half the stores in this town have help wanted signs. They can't have enough business hours open because they don't have enough workers.
I've been putting out applications everywhere, like factories. They haven't been getting back with me. Just try GM. I just got denied. I had a job. They told me I had it, but when they read my background, I had a felony background.
You have 10 times you've been in front of a judge. You got quite a history here. But there are employers who take felons. How about school? How'd you do in school?
It wasn't really my thing. The subjects I liked was math and science.
Well, those are the subjects I hate. Those can get you really far in life. Most lawyers don't like math and science. That's why they're lawyers. Okay. What do you want to do? You want to work at the pizza shop the rest of your life? You want to own them? You want to own it or work there?
I would rather own a piece of shop than work there.
Okay, how can you get there? What do you want to do?
Gotta put it in the ground and start working hard. Working myself hard.
Okay, and that's nice tuning in a song, but how are you going to get there, sir?
I gotta find a better job and start.
Okay, so I'm going to sentence you to your jail, but I'm holding the banks. Counsel, don't come to me with another song about his family. I'm not going to listen. You don't chat about the hard work he's got to do. Sir, you got 4 kids and you're not supporting them. You're supporting 2 that taking child support. What about the other 2?
My son lives with my 15-year-old. He lives with me.
Okay. Are you getting child support from the mom?
No.
Why not?
We haven't had an agreement. She get them on the weekend and all. I haven't gone to school. She get them on the weekend.
So what? You're there most of the time. You're entitled to child support. I mean, I haven't run the numbers. That's a family court job. Is she working?
Yeah.
So you don't think that some of her paycheck ought to go to pay for his necessities?
I mean, yeah, it can, but I'm not gonna say that she doesn't help because she helps.
Okay. And what about the other child?
My other child, my oldest son and her have the same mom. They live together. I can't really say they don't take the child support out because she's on the case file, but it don't never say they take that out for us. So I don't know how that works.
Well, why don't you get it? You're entitled to a child support review every 2 years. Why don't you figure that out, sir? It takes 2 to play and 2 to pay. And child support is the right of a child and an obligation of both parents. Now, I'm not that smart. I didn't write that. Okay, that's written in the law. That's written in the case law. Every attorney should be able to recite that. That's just the way it goes under the Constitution and the rights of parents and children. So, the law does not reward anybody who sits on their rights. So figure it out, sir. Go to the court downstairs. There's a piece of paper on the desk. You can just put your name and file numbers or what have you. And if you don't know, they'll help you get it. And you just ask for a review of child support. It doesn't cost you anything. They'll figure it out. So, have you ever thought about college?
No.
Why not?
Just never proceeded.
Why?
Back then, I would just.
Well, I'm talking about now, sir.
Right now, it just never crossed my mind to go back to school. It just hadn't. Not saying that I can't or won't. It just hadn't.
Okay. Well, LCC has a program that's free. How much have you gotten in your life that's free? Not much, huh? Me either. But LCC has a program. I don't know if you qualify, but it is called Reconnect. It is meant for people like you who've been out of school for a while. I'm going to ask you to investigate that and look at what you want to do in the future. You want to own a pizza shop? take some business classes. You want to do something else? They got lots of opportunities over there. There's two things people can't take away from you. Your name and your education. And your education is an insurance policy to your future. Selling drugs, criminal behavior is your insurance policy to abet the Michigan Department of Corrections and being an absent father. Choose. You are going to be on probation for 24 months. You shall not use, possess, purchase in the presence of any alcohol, illegal drugs, drug paraphernalia. You end up at a friend's house and they have all that. For any of that, you're just doing about face and you leave because they may not get in trouble, but you will get in trouble. You need to change your friends and your lifestyle, sir. Otherwise, your lifestyle becomes real easy. It's jumpsuit, some Crocs, 3 hots and a cot. You get to shower and eat and do all those things that people do under the watch of the Department of Corrections or the Aiken County Jail. If that's the lifestyle you want, you got it. Be the example to your children that you can make a mistake, but you can learn from it. These are teachable moments, and you can achieve the greatness that you were born to. Every human being, including you, sir, is born to greatness. It's a question of whether you achieve that greatness or throw it away. But right now, I see you throwing it away. So you go the other direction and achieve the greatness, or you will achieve a bed in the Department of Corrections. Be clear?
Yes, Your Honor.
So were you using or just selling? Looks like you had alcohol and marijuana, but you didn't use. Is that right or not?
Correct, Your Honor.
Okay. How about marijuana? Are you still using marijuana?
Yeah, I was. I have a medical marijuana card.
Okay, so you will only use the marijuana as prescribed. When we test you for drugs or alcohol, which will be random, doesn't have to be regular, doesn't look like you have an alcohol or drug problem, we will test for the levels in accordance with that prescription. So you're not allowed to be high every single day. You're allowed to use it as prescribed for whatever medically ails you. Got it?
Yes, Your Honor.
Any prescriptions you receive, you'll present to probation within 24 hours, and you will sign all releases so we can verify that you're doing what you need to do. Before September, actually before August, you will investigate the Reconnect program and see if that's something you want to do. If not, you will also investigate trade school. There's a lot of opportunities for you. You're not making it with Sir Pizza, nothing wrong with Sir Pizza. They got good pizza, but it's not a career for you with 4 children, not making ends meet and looking at criminality to support and subsidize your lifestyle. Not happening. It's not working well for you. You can support nobody if you're incarcerated. So I'm giving you this opportunity. You can use it wisely or throw it away. Your choice. You will not give any employer any cause to terminate you. You will not have any abusive, assaultive behavior, verbally or physically. You will not be in the presence of any known gang member. Shall not wear any gang colors, insignia, or gang tattoos. You will not be in the presence of anyone who's on probation, parole, or in the Michigan Department of Corrections unless you have our permission and everybody's in good standing. You will allow probation into your residence or supervision if there's reasonable belief that you're violating, and they'll be allowed to check without a warrant your residence, cell phone, computer, vehicle, anything you have access to. Do you understand?
Yes, Your Honor.
You will participate in cognitive behavioral therapy. You will not have any guns, ammunition, imitation of a weapon. You'll not be in the presence of anyone who has those. You'll not use any object as a weapon. You end up at a friend's house who has any contraband, you do an about face and you leave. They may not get in trouble, but you will. We're clear on that?
Yes, sir.
You have 365 days jail credit for 2 days. Balance is held. They'll report to probation every time they want to see you, no less than monthly. And you need to miss an appointment, then that's on you. You chase probation, they don't chase you. You will keep them informed about your employment, your school, your address and telephone number. Anything changes, you have 24 hours to tell them. If you have police contact, personal protection order placed on you, any change whatsoever, you have 24 hours to tell them. And sir, if something happens on a Friday, tell us on Monday. Monday's a holiday, tell us on Tuesday. That's how that works. Do you understand that?
Yes, sir.
You will pay private to assessment amount of $130 and a state cost in the amount of $68. I am waiving probation oversight fees for my distribution for that and any and all other costs. And counsel, were you retained or?
I was retained last time. Just
All right, so everything else is waived in terms of fines and probation oversight. Is there anything I have missed?
That people, Your Honor, thank you.
nothing to just thank you very much.
Sir, this probation is for your rehabilitation. It's up to you to do the hard work. Additionally, it's up to you to be honest. Now, if you decide not to do the Reignite program or go to trade school, you might need to get a second job. Things are going up. Gas is what, $5 a gallon? Eggs are expensive. Everything's expensive. So get a second job. But again, if you can lose a job, you can't lose your education. The Reconnect program, hopefully you qualify for that. But there's also a lot of trade schools. Work with probation to figure out what your next step is. And climb the mountain of success. Right now, you're at the bottom of the mountain and you don't know which next step to take. There are counselors who can advise you. Probation can work with you. Ask for help. That's a sign of rehabilitation. That's a sign of strength. I don't believe that you want to be in this place. I think you think your options are limited, and they are not. The only one limiting you is you. Let's get past that. Move past your fear. Failure is just another teachable moment. It's okay to fail. It's not okay to not try. You hear me?
Yes, Your Honor.
You have 42 days to appeal and to request appellate counsel. Please give Ms. appellate rights. They're right there next to you, counsel. Acknowledge you receive your appellate rights. If you don't like this, you just appeal. That tells you how to do it. You have 42 days. Okay, sir?
Yes, Your Honor.
Meanwhile, go downstairs, make an appointment with probation. Ground level, keep all appointments. Counsel, if you direct him, that would be great. Thank you.
Thank you.
Good luck to you, sir.
Thank you, Your Honor.
Right now, Christopher Guzman. I'm gonna need your lawyer in here too. Did you meet with your lawyer?
Yeah. Just stepped out.
Okay, so we'll get him back in here. How's that? Okay?
He's coming in.
Carter, Sherelle Carter. 26W841163, 26W841067. Come on up here real quick, ma'am, and tell me your name. Did I give you a lawyer?
Yes.
Who's your lawyer? Okay. Okay, look, I'm gonna.
Hold on.
You would have to give you credit if you gave credit.
I give it to Deanna. I gotta find out what she's at.
All right, why don't you have a seat too, ma'am? I'll be right with you. Who do you have?
Guzman.
There, Kristen Fern Guzman, 267841847. I don't know if the victim is here, but I need to apprise you of something. Ma'am, your name?
Kristen Guzman.
Michael Department, D73824 on behalf of the
I don't usually fight him on this, but all these charges she's got pending, and she had an assault and battery, and there was a PPO violation. I am not taking this under section 771. This is not right. So I'll either let you go back, ma'am, I'm gonna let you withdraw your plea, go to trial on it. I'm not taking this under a first offender statute, given the nature of all the rest of these aggravated stalking cases that are going on. So that's my decision. You can discuss it with your lawyer. I'll allow you to withdraw your plea and go to trial, or you can say, Judge, I understand you're not gonna take it under 771.1. I'll invite you to sentence me, or maybe your lawyer can go talk to the prosecutor, but that's what I'm gonna do. So I'll put,
For clarity, you're not taking under 771 based on pending ongoing charges.
plus the fact that she had an assault and battery, plus the fact that she had.
Those are convictions.
There's an assault and battery conviction in 24 plus a PPO violation.
Sorry, I don't have the whole list.
That's okay. She had an offense date of September, she had an assault and battery, and she was discharged from probation in December of 25. The conviction occurred in July of 24. She was arraigned on a charge of domestic violence and a PPO violation at the 24th District Court. That offense date was September 20. She still has it. There's been no conviction on that. She's got warrants all over the place on cases, well, I should say pending cases involving domestic violence arising out of a June 8, 26 incident, aggravated stalking from that date, another aggravated stalking from that date, another aggravated stalking from that date. So that's
The primary reason for the court denial is because of the conviction.
the assault and battery conviction and the fact that there's a PPO violation. Okay?
I would like to talk.
You go talk. First, Kristen Fern Guzman, 267841847.
Michael A. Carmen, D73824 on behalf of the defendant, Your Honor.
Ma'am, your name?
Excuse me, Kristen Guzman.
All right, so this is gonna be a plea to stalk, not taken under 771.1, correct?
Correct, Your Honor.
Wait, how did all this end up in this blue folder here? All right. Need a second, jeez. Ma'am, you already took your plea to stalk.
What up, Carl?
Back by 9:30.
So
Would you get
okay, hang on a second. I got the file and I just want to make sure I got everything in the right place. For some reason, I got put in that blue folder. So rather than take a plea to stalking again, I just need an understanding from her that she understands I'm not going to take it under section 771. Do you understand that?
Yes.
So you understand this conviction will remain on your record? And you understand I would have allowed you to withdraw your plea and proceed to trial since I told you I wouldn't take it under that statute? And notwithstanding that, you still wish to plead to stalking, knowing it won't be taken under section 771.1. Is that correct? All right, so I don't see any need to take the plea unless you do again.
Your Honor, just for clarity, I did go back. I talked with the prosecutor. He was not willing to offer any, I guess, amended charge. What he did write was that he didn't have any objection to any incarceration in this matter. So I think she's still getting, some benefit of it
Sure.
being pre-trial.
Sure. Do I have the victim here by chance? I want to make sure I saw the victim's letter, and I want to make sure that she's not here. Michelle Fonseca, is she here by chance? Has she been here on Zoom at all, Heather?
No, Judge.
Did you read this victim's rights letter? Did you get a chance to review it with your client?
Yes, Your Honor. I read it and I gave it to her to read.
All right. I just want to be sure that, and if you had a chance to review the report with her, the pre-sentence, and are there any material additions, corrections, or deletions?
Your Honor, one material addition, my client is also working at Sally's Beauty Supply part-time, usually just twice a month, and she earns $14 an hour there. Otherwise, everything seems to be accurate, would ask the court, adopt the recommendations. But I guess since, she can't use the 771, I would ask that the court consider shortening the probation to 6 months, please.
I have real concerns about Gina's Guzman. Would you like to tell me anything? I can't hear you.
No, Your Honor.
And I don't want you to talk about any of the other charges that you have pending. But you got a lot going on here, young lady.
Sure. I'm trying to get everything straight out.
Well, one of the things you can do is stop harassing and stalking people.
I'm taking a break from social media. I deleted that app. And I've just been concentrating on working two jobs. Staying out of trouble.
Well, I sure hope so. I wonder, local ordinance, this stalking charge is just a 90-day misdemeanor. But I'm just telling you, I have real concerns here about what you're doing.
I understand.
18 months probation. You cannot leave the state without consent of the court or violate any law or ordinance. You must report to probation as direct. You're to attend a psychological evaluation and treatment if recommended. You're not to have any contact with Michelle Fonseca. You're not to possess firearms. You're not to possess dangerous weapons. You're to serve 7 days or 56 hours of community service. I'm going to give you until August 15th to complete that. No contact. We understand that.
I understand.
100 fines, 200 costs. 75 victims' rights, $50 justice assessment. That is $4.25. Screening fees $60 for $485. Probation fees are $360. Bring your total to $845. You may be eligible for early discharge if you're compliant. So after 9 months, if you're compliant, you can come in here, and by statute, you would be entitled to early discharge. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. I'm going to let you, do you have any money to pay today?
I can make payment.
How much?
I could put $100.
And then how much could you pay weekly, you think?
I get paid every 2 weeks. So
When do you get paid next?
26.
All right. How much can you pay bi-weekly? I'll only have you do 60. Pay 100 today, 60 bi-weekly beginning June the 29th. Now, if you ever need more time, no problem. Come talk to me on or before the due date, or you can call the court. We'll go on Zoom. I'll give you an extension. We will meet with probation. So go down to $100. Go over probation, no instruction. Any questions?
Just for the cashier to pay the $100.
Correct. Good luck. Thanks. Purcell. People against Deanna Lynn Purcell. Hughes 5 W8398. I'm sorry, 83968 A and B. Ms. Purcell, you're
Deanna Lynn yourself.
Michael A. Carmen, 37384, on behalf of the clinic, Your Honor.
all right. So we got attempt possession of a controlled substance she's going to plead to, right?
Yes.
That's on file count 1, file A. Jamie Antonia Williams Bay, 23W831736. She's not here, is she?
She's on Zoom, Judge.
All right, ma'am, your name?
Jamie Williams Bay.
You're charged with failure to pay fines and costs. You have the right to a lawyer. If you want one, I'm going to give you one. You want a
Yes,
lawyer?
sir. Yes, sir.
Okay, so we'll give you a lawyer. And Heather, who will be doing this today? It's a probation violation.
Well, Tony Carmen's our house counsel today in place of Crawford.
All right, so we'll give this one to Mr. Carmen. Counsel?
Michael A. Carmen, P7384, the Head of the Your Honor.
I don't know what to do with her. She owes all this money. She's owed all this money.
Mm-hmm.
What am I supposed to do with her? Does she have, please tell me she has the money so I don't have to send her to jail.
Well, my client paid a $200 bond. He can pay $400 today and then the balance in a week. Jamie, is that accurate? Jamie,
Yes.
hear what I just said?
I'm sorry.
Did you hear what he just said? He said you could pay 400
Oh, yes.
today. You posted a $200 bond and that you could pay the rest in a week. Is that what you said?
Yes, that's what I said.
And Jamie, is that accurate?
Yes, that's what I said.
Did I ever revoke her height status, Heather?
Let me take a look here, Judge.
April 21, I said.
I don't see that we did. Because it's still a non-public status in our system.
Who's your probation officer again? Let's call in.
It is Miss Wilds.
Let's call in Beth, please. So I want to read my notes. On April 21, I took her plea. I set a sentencing date for May 27th, said she was to attend the Positive Strategies program. She was going to bring proof to defense attorney. DJ something program at Oakland Community. She used to take care of at least a couple. Well, I just can't even read my own writing. It got a little ugly there. Is Beth coming?
She's on her way.
So I took your plea on April 21. Did she do the Positive Strategies
I
program?
believe that's scheduled for Jamie said July 9th.
Yep. 6 p.m.
And then what else did I say? Bring proof, defendant, attorney.
Criminal justice transcript from my school.
Did you bring proof of that to Ms. Wilds?
Yes, I sent it to Miss Wilds. Yes, sir.
And then it said defendant to take care of at least a couple other warrants. Did you do that?
Not that I'm knowing of, because I didn't even know I had anyone.
Wilds,
Classification, Your Honor.
how's she doing on this?
I'm gonna say not well, Judge. The last time we were in court, you did order her to complete the economic crime program. You ordered her to provide proof of schooling, which she did email to me, an unofficial transcript. I think last time she said she was going to school for criminal justice, but it appears legitimate, but I can't decipher what school it's from.
Oakland Community College.
And you ordered her to clear some of her warrants off. I think at the time she had to post a bond, and again, to discuss the money at today's hearing as well. So those were the items that you addressed. At the very, very last hearing, I believe you adjourned it to today, because of the lateness in the day, if I'm correct.
You are not very responsive. You know that? Yeah.
I'm trying to get everything together now. Like, this was all down the line when I didn't know anything. So I'm just trying to get everything together now.
I mean, I won't forget this case. This is the one with the lottery tickets, and you and your lawyer were trying to blame the manager for encouraging you to take the lottery tickets. I mean, I remember going through that. That was ridiculous. Like, I mean, It was beyond ridiculous. And then you just kind of went AWOL on us. We didn't see you from October of 23 until April of 26. You did send a letter in June of 24 saying you wanted to appear by Zoom. And I said, no, you had to appear in person. Now, I don't know what to tell you, Ms. Williams-Bay, but you are only 23 years old. True?
Yes, sir.
It's time to start acting like it.
Yes, sir. Honestly, I'm literally working 3 jobs now because my Amazon job not posting shifts. Because I'm working flex, but I got two other jobs, picked up 2 other jobs, and I've already started them. And I'm definitely dedicated to getting this out the way because I should have been got this out the way. And this is just catching up to me because I should have been got this out the way.
I can't revoke your height status at this point. When's the program? What'd you say the program was? What day? Positive strategies. When you going to that?
July 9th. I'm already scheduled.
Sorry?
All right. Is Mr. Carmen, is it going to be easier for you to take the 13th or the 22nd?
Yeah, they don't have a phone on me. It's in the other room. I'm gonna grab it and look.
I think Heather may know. Heather, do you know when Mr. Carmen's here again?
Let me take a look at the calendar here. So we're looking between the 2 dates that we have coming up in July. He's not here on the 13th. Let me look at the 22nd. He's not here on either one of those dates.
Well, let's adjourn it to July.
Yeah, we're actually still looking for an attorney for the 13th date. We don't have one yet.
We're going to adjourn this to July 22nd at 8. Is it 8:30? Is that good?
Yes, that's good, Judge.
I expect everything to be done.
Yes, sir.
I expect everything to be paid.
Yes, sir.
Okay? And then I can figure out a way to, geez, you got to be more. That's all I'm going to say. Have a good day. Kenneth Mandel, thank you both. Murph McCurdy III, 26W84304, 7A and B. Good morning, Mr. Camilleri.
Good morning, Judge Attorney Jack Camilleri on behalf of Kenneth Mandel, McCurdy III, President and Court.
Sir, your name? All right, so we have a charge of operating while intoxicated, and we also have a charge of minor in possession. As I understand it, first of all, he's going to stand mute and waive formal reading. Is that true?
Correct, Judge.
And then they're going to dismiss the MIP. They're going to dismiss the OWI. He's going to plead to impaired driving, and they'll move to dismiss the 2 counts, correct?
Correct.
Is that what you want to do, Mr. McCarty? You plead guilty to operating while impaired. Here are the possible penalties: up to 300 fines, 93 days jail, 360 hours community service. Court costs are all of those 4 points. License suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that? And did you sign, read, and understand the advice of rights?
Did you read and understand?
Yeah.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Sure.
All right. To the charge operating while impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on May 24, 26 on Western Hall and Woodhaven? You got to keep it going.
Oh, yes, sir.
Was that at 6:57 in the morning?
I believe so.
Did you drink alcohol prior to operating that vehicle that day?
Yes, sir.
What did you drink and how much?
Like 5 beers, 6 beers.
What time did you stop drinking the 6 beers?
Late in the morning?
Yeah.
Was it early morning?
Yeah, it was early morning.
Like early morning? You mean 2 in the morning?
Yeah, somewhere around like 2, 3.
And you were operating this vehicle, and where were you going?
To the store, I believe.
Why were you pulled over by the police?
Speeding.
You think you were speeding, at least in part because of your alcohol consumption?
Yes, Your Honor.
And counsel, were the results of the breathalyzer 0.149, and you stipulate that that was an accurate reading for purposes of the plea?
Stipulated,
And was that a breathalyzer or intoxilizer?
yes.
And how old were you at this time? You only 18?
Yes, Your Honor.
And are you on probation or parole?
Not right now.
Anybody force you to plead guilty?
No, Your Honor.
Please accept it to operating while impaired. The OWI and the MIP are dismissed. I'm going to refer you for a screening assessment. We have to address bond. Who's this with you?
Mother,
This is not good. You can't be doing this at 18. This is bad. I'm serious as a heart attack when I tell you that. I'm not overreacting either. When I see people come in with drunk drivings at that level, when they're 18, they really do typically come back with another one because they have a serious drinking problem. I'm not trying to make you feel bad. I'm just telling you the way it is. I'll give them a personal bond of $1,000. My court officer is going to hand you a form.
Your Honor, there was a pending charge.
He's got another charge pending?
As an officer of the court.
For what?
OWI.
In front of me?
No,
From Judge Hessen?
yes. I'm not gonna try to say that my client was given lottery tickets. I was here before what you just said about the other one. I've been in front of you way too many times. And I feel compelled that I gotta tell you there's a pending charge.
Well, I appreciate your honesty. That's what I expect lawyers to do. And I appreciate it.
I just
Some
looked it up.
person-
He goes in front of Judge Hessen tomorrow on that one, it looks like.
Has he gone in front of her for arraignment yet?
No.
No, he has not.
So this is not good. You know, did you graduate?
Yes,
From where?
Clarkson
What is your plan for the fall?
Community College in Florida for a year.
You might want to save your money. You keep getting in trouble like this. I don't care if you go to Harvard and are the valedictorian. Nobody's going to want to hire you. Now, I don't want you to say another case about that, another word about that case. You're representing them on that too?
Yes.
Good.
Give them my Oscar winning.
Listen, I hate to, here's what you're doing. I'm telling you, I'm not impressed. AANA 3 times a week. You're going in person, no alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. I want you to understand also, you will be on a Soberlink device by the end of the day. Probation's going to explain that to you, how you go about acquiring that. You're gonna have to blow into that machine 5 times a day. Your party days are over. You got it?
Yes, sir.
Good. I mean, I don't want to say too much because I don't want you to say anything to incriminate yourself, but my Lord, after you had this one, I'd have thought you'd be pushing the car before you'd even be driving the car, even if you hadn't consumed any alcohol. And now I find out that you got another case pending. Bad, really bad. You better get your act together now, son. His father, are you still married to his father?
Father's passed away, Judge, when he was 15. He had a pulmonary embolism.
Yes.
I'm sorry. And you're raising this, is this your only child?
No, I have 3. He's my oldest. I have 3 younger ones.
You gonna be a good example or a bad example?
They actually work together, Judge. Mom was referred to me by a corporate client. Kenny here works at the same corporate client, so they work together. I have said so much to Kenny in my office, Judge. I don't know if I'm annoying to them, but I tell them about reality. I tell them about generations before him, how they had so much on their shoulders and they were responsible. I talked to them about Judge Kirsten in his World War II. You know, all those guys were 20, 22, and look what they went through. Look what they did. And they weren't belly aching about too much responsibility. And I've been to Omaha Beach. I've been to Normandy. And these guys have got to realize that, first of all, they can do 3 times more than they know they can do.
Right.
Second of all, they got to realize that we're giving them a pass in today's standards versus what things were like 60, 70 years ago
No
for
doubt.
them.
No doubt.
And bad things happen to good people. If you think that it won't happen to me, BS.
Right.
Okay? BS. shit happens, and you can wrap people around the telephone pole. You can wrap yourself around the telephone pole.
Exactly.
You know, it can go on.
I'm glad you're talking to
He's
him.
a good guy. I can tell. He just needs to be woken up, put on the right path.
Right.
Mom's been in my office. I give her a lot of credit.
I'm glad you're talking to him.
Oh gosh, I go on and on.
I know, I'm sure. Did I give you a sentence date?
You didn't have to listen.
What's a sentence date, Heather?
The 22nd at 8:30.
July 22nd at 8:30, good with you?
Yes, Your Honor.
And you're gonna go meet with probation, you're gonna fill out a questionnaire. You write that on my register, will you please, Heather? I kinda just put it on.
Yes,
And you're gonna go get that Soberlink today. You got it?
I'll explain to him.
Okay, thanks a lot. We'll
Yeah.
see you here then. Get your life together. Good luck. Thanks.
He
Thanks a
can
lot.
recover. He just has to
Right, buckle
get on
down.
the right track.
Exactly. Thank you.
Judge, did we dismiss, I'm sorry, did we dismiss the MIP on that one?
Dismissed in the MIP and the OWI on that.
Okay, perfect. Thank you.
Thank you.
Mr. Deal still has one.
All right, thanks, Judge.
Thanks a lot.
Yep. Go up.
Mr. Campo? Campo, I mean. This is a 1 o'clock, but it is a GF, and this man and his wife just walked 2 hours to be here this morning. And I don't believe that we have anything filed, do we?
No.
You can have a seat, sir. We will go on the record in the matter 26 GF 133, group file of Brandon Campo. Appearances are we do have appearing in person, the district attorney, Kevin Schmidt. Mr. Campo appears in person without counsel. We are in victims' rights compliance because the victim is sitting right back there, Ms. Bauer. That is the victim. Look at her face. That is who she is. And so we have Mr. Campo here. This matter, he was brought before the court for the court to put him on a cash bond, a significant cash bond on May 26, 2026. There was enough there for the court to make a probable cause finding because the court does have at least a small police report in this matter. And so he's here. It was scheduled at 1 o'clock, but the man and his wife have walked 2 hours to get here. Correct, Mr. Campo?
That's correct.
You don't have a means of transportation?
No.
And so why are you here at 1 o'clock? Or why are you here now instead of 1 o'clock?
I was trying to get the court date changed because I don't have an attorney.
Because you don't have an attorney, but I understand that, but you don't even have charges filed against you. You understand that part?
So I didn't have to appear?
I would say probably no, because there's nothing filed, but you do have cash, $1,000 cash that was posted based upon a very lengthy probable cause statement with facts enough that you could have been charged or probably should have been charged by now, since it is June 24th. Almost a month past the date. You are dressed very nice for court. Thank you for wearing a shirt and a tie. You look fantastic.
Thank you.
Why don't we have anything charged? Almost 1 month to the day or two later.
Because one of the charges lacks probable cause in the police reports.
Then don't charge that charge, but he should be charged by now.
No, because I've asked for police follow-up to find the probable cause for that count.
I thought you started
Multiple
something in Polk
requests.
County where the day that they're arrested, they get probable cause, they get their initial appearance, they have a complaint filed. This should happen here too, because it's almost 1 month since this man was arrested, put on bail with significant cash of $1,000 with bail condition. If there's one count that is not yet enough for probable cause, then you can ask to amend the court. You know the statute, you know the rules. But now we have a man here who he's been under a bail bond condition for almost 1 month with $1,000 cash, and we don't know if there's enough to charge. There's enough at least for probable cause for some of these. You can amend later. You can even amend an information upon preliminary hearing. Right now, this is ridiculous that it's almost 1 month since his arrest, since he was put on cash bail, that he has not been charged.
Judge, we wait for complete reports before filing complaints because our policy is that cases are provable and triable the day we charge them. It's not right now. That is my office's policy.
You can't though,
If
you
the
can't
court-
prove and charge any of these, so you don't want to file anything, because again, discussions of the fact that when you worked at Polk, you developed this system and it's to have all of these things. I don't know if you did that or who did this, but when a man's arrested or a woman's arrested in a lot of counties in the state and per the statute, they are to be immediately provided their criminal complaint. Is it directory? Is it mandatory? Who knows? But in a lot of counties, it happens the day of arrest. And there are amendments to the criminal complaint or amendments to the information. But now it is June 24th. And again, this man was arrested on May 22nd, he was arrested. May 22nd, he was arrested. But the court did place bond and cash on him on May 26th.
Correct. If the court conducted a bond hearing within 72 hours of arrest, I could have told the court of this, but our county doesn't do that.
Our county should do that. Our county should do that, because I guess I'll pull up the statute right now. Because people's rights are restricted. That's why most, or a lot of counties, I can't say most, because we're one of the little counties that apparently don't want to do that. I'm sure you know the statute and you can probably pull it up a lot faster than I can, since that is your job every day. The state must file a complaint without unnecessary delay following arrest, which generally can be interpreted as 48 hours. 48 hours. And that's not just for the court to determine bail, but it should be filed. It should be filed with unnecessary delay. And to this court, this has been beyond an unnecessary delay. When a person is arrested without a warrant and brought before a court, before a judge, a complaint shall be filed forthwith. Forthwith.
This person was never brought before a judge. Bond was set in his absence.
The probable cause was brought before the court with enough information for the court to determine probable cause. So if we're going to start having people arrested and they're going to be brought before the court, then forthwith a complaint will be filed and we will start having bond hearings every single time a person is arrested. This is outrageous. It is completely outrageous.
I would approve of that process. That's why Captain Taggart asked the court to.
Oh, good. Then we're going to start doing that now. And so we will have a complaint filed forthwith at the bail hearing, correct?
We will not.
Then we will not arrest people. Then they will be not arrested and we will not see them, because bail should not be placed on a person unless a person is arrested without a warrant and brought before a judge, which they will be. A complaint shall be filed forthwith. And if other counties, including Polk County, can file it and get it done the day of the arrest, within hours of an arrest, I think Burnett County can do that too.
We will file it forthwith after those bond hearings if the court starts bond hearings.
All right, then I'll do that and we'll have the bond hearing and then the very next day we'll have the initial appearance. That was forthwith for the court. So is that what we're going to do, Mr. Schmidt?
I'd have to confer with law enforcement because they have not been consulted with this yet and not been given an opportunity to prepare.
There's enough. Do you understand what the PC comments or complaints that are filed, the probable cause complaints? They have a lot of information. They are puked with a whole lot of information. The officers do such a fantastic job for the most part in those probable cause statements. Enough where a complaint can be filed. Enough. I can even read this complaint that was filed by the Siren Police Department. There is enough there, right there, enough there that a complaint can be filed. That is forthwith. And all you do is cut and paste and put their complaint into the complaint, or their police reports into the complaints anyway.
Judge, the probable cause statement, you may have noticed, does not state when the drinking occurred in regards to when the crash happened. does not state when the moment of driving was. It does not state whether an officer was actually spat on or not. And it does not say whether anyone was injured in the crash.
Well, then that is a Siren Police Department issue that you can talk with Siren Police Department. But I'm going to tell you, our county boys and girls and women and everybody, all of our county people, our county officers and deputies, they put a lot into their probable cause, a lot.
They do.
And so then I guess with Siren Police Department people, if that's what you're saying is the issue here, then perhaps they need to be trained on how to put in all of the information in a probable cause. So we can forthwith have charges.
And again, I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. Then we cannot have bail or bond conditions. So people need to be let out immediately, forthwith.
We can have bail conditions set based upon probable cause statements, and the complaints can be filed forthwith. We have the capacity to do that so long as law enforcement knows and they can prepare for it.
All right, forthwith, within 48 hours, I will do bail. Within 48 hours, we will have the initial appearances in every single arrest, every single that comes in front of this court for bail and bond.
Okay. I will speak with law enforcement of what the court's command is. I am going to be gone for the next 2 weeks, so there will be that problem.
Because to me, forthwith does not mean 1 month and 2 days after an arrest. That is not forthwith.
It does not. If there was a bond hearing, I would have told the court to do a signature bond for these reasons.
I would not do any bond, zero bond, none bond, because unless it's forthwith within 48 hours, nobody should have their due process rights taken away because we can't get a criminal complaint filed forthwith.
I agree. It is unreasonable for people to be on a cash bond without seeing a court and no.
Any bail bond conditions, any, because right now, this individual, if I have him on bail bond conditions, this individual, and he's not getting a complaint filed a month and 2 days after, why should he risk to have bail bond jump violations when he hasn't even been charged? He doesn't even know if he is going to be charged.
I agree.
So zero bail, zero bond, unless we have a criminal complaint filed forthwith within 48 hours.
I agree.
Done. Then that's what we're going to do. So, Mr. Campo, I'm not sure if you are supposed to have a complaint filed today. I'm hearing no.
Okay.
So you are forthwith discharged from all bail bond conditions. Forthwith. Now.
Really?
Immediately. Cash will be returned to you. And bond, gonzo.
Amazing.
Okay? Thank you.
Thank you.
Nicole Cook.
Yes, sir.
All right, we'll go on the record in State of Kansas versus Nicole Cook, AKA Amber Cook, case number 26 MR 125. State appears by Joseph Baca. Miss Cook appears in custody from the Butler County Jail. Looks like you're here, Miss Cook, because the state of Oklahoma has a warrant for you, and they're wanting you to come back and take care of this.
Sir, we went through all this, and they dropped it from what I thought because it's not me. My name's not Amber. Our social security numbers didn't match. Our tattoos don't even match. That's not me.
All right. Well, give me just a second to read over this information.
Okay.
All right. The fugitive information indicates that a written complaint and warrant was filed in Oklahoma City, McCurtain County, Oklahoma, alleging that you committed an offense there, interstate compact for adult offender supervision.
Since I've been here, they said that they came down and told me the other day that they got it figured out and that this was dropped because it's not me. It's really not me. I've never been to Oklahoma as an adult.
Okay, let me continue reading through the paperwork.
Okay.
So you're claiming you're not Amber Nicole Cook?
That's correct. My name is Nicole Cook. I have no middle name. And that is not my social. And I don't have any ankle tattoos or anything like this girl does. I know it's weird that so much matches up, but I'm not her. That is a different girl.
Yeah, I'm not seeing any information about tattoos. I see a date of birth, a social security number.
Here at the jail that we've been trying to get it figured out, and they came and told me that, I don't remember which one it was, that the Oklahoma dropped it because they found out that it wasn't me. So I don't understand why we're back to square one again.
Okay, Mr. Baca, do you have any information?
Judge, I think I'm looking at about the same amount of information you have. I do have a date of birth. I do see that what I believe this is either a probation violation of some sort out of McCurtain District Court, out of Oklahoma, is what this relates to. But I don't really have much more information than that.
They said they sent my fingerprints and stuff to Oklahoma to make sure to show them that that wasn't the same girl, and that when it came back, that they dropped it. And I thought this was over with.
Okay, there's a couple mug shots in here that sure look like you, but I don't know where
I know they do, and it's weird. But yeah, they said the jailers here said that they had called down there and they'd gotten it all figured out already. And Clemens is working on getting the thing. She said she just stopped me out here and told me to let you guys know that they're working on getting it figured out or whatever.
Well, it looks like it is probably a probation violation for a burglary, and looks like possession of a sawed-off shotgun.
Yeah. I would never commit none of those crimes. I just have a drug problem. That's it.
Well, they at this point believe they have the right person. Do you wish to have an attorney appointed?
Yeah, that would be great. This is ridiculous. They, why would Oklahoma have already dropped it and now they're back on it? Because that for real is not me.
Okay, well,
I want to go home and I can't because of this.
You're not wanting to waive extradition?
I don't know what that means.
Okay, well, there's a signed waiver of extradition attached in the information that I have.
I don't understand.
Allege that you signed it, meaning that if you're picked up by another jurisdiction in another state, you agree to go back to take care of this.
That's not me.
So you're saying here today that you were never on probation or supervised in Oklahoma?
That is correct, sir. Very, very correct, sir. That is not the same girl. I am not that girl.
Well, law enforcement seems to think that it is.
I don't understand why they've known me my whole life.
So I'm going to appoint James Watts to represent you.
So what could I do, like in right now, what could I possibly do to help this get figured out? What does that mean?
You may want to visit with Mr. Watts. It's a no bond hold.
Yeah, I know, and I can go home, but I can't now because of this. And I am going to lose my job and everything I have because somebody got me mixed up.
I'm going to set a court date for you, July 20th at 2:30 p.m.
Okay. So
that's going to be on my felony preliminary hearing control docket.
So even if I bond out of the other stuff, I still have to stay here until then?
Unless this is sorted out and they determine that it's not you.
I hope they told me they'd already done that.
Okay, well, that doesn't appear to be the case.
This is not right at all. This is not right.
Mr. Baca, anything else?
No, sir.
You might have today?
Judge, I don't have anything. I would let Ms. Cook know. Obviously, this is being streamed. We don't want to get a lot of personal information, but you might try to talk to your attorney and compare the date of births. They can look into that could be a suggestion, but
A lot of our
don't have
stuff
any other
doesn't match.
information.
They've already compared a bunch of stuff and it doesn't match up. So, I mean, they already know that it's not me. The cops here, the guards here already figured out that it wasn't me. So I don't understand why this is still happening. Because Oklahoma won't agree to it? Is that why? I mean, I don't understand.
I don't know what's going on. All I have is the paperwork that I've been handed, and according to this paperwork, they're of the belief that it's you, and they're wanting you back. So.
Okay, well, okay.
All right, you've got an attorney appointed, you've got a court date
Yeah.
coming up relatively soon, so if there's nothing further, we'll be in recess. Thank you, Ms. Cook.
Sir, good morning in the Nisqually Jail. What is your name, please?
Jose Adrian Martinez.
And Mr. Martinez, I show that your date of birth is July 20th, 1998. Is that correct?
That's correct, Your Honor.
All right. Mr. Martinez, thank you. You have 4 matters before the court this morning. Let's see. 3 of those matters are, all 4 of those matters are on for pretrial conference. And it does appear that you are represented by Mr. Wood's law firm on each of these matters. Mr. Wood, how would you like to proceed with Mr. Martinez's pretrial conferences at this time?
Good morning, Your Honor. I just need a brief breakout room with Mr. Martinez. Just a moment, Your Honor. Thank you.
Okay, we are on a tight clock this morning, so try to keep it very brief if you would, please. Thank you.
Understood, Your Honor. Yes, I will be fast, and yes, Your Honor. Thank you.
Officer in the Nisqually Jail, if you could please assist us in placing Mr. Martinez in a breakout room. Mr. Wood, have you had an opportunity to speak with Mr. Martinez?
Yes, Your Honor, I have. Thank you for that additional time, and I believe we're ready to proceed now.
Thank you, sir. How would you like to proceed with Mr. Martinez's 4 pretrial conferences at this time?
Thank you, Your Honor. I believe we're very close to a resolution, but we're not ready to enter it today. I'm asking for a very short set to set this over to this Friday's calendar in anticipation for a change of plea on that day.
Ms. Tuaninga.
Your Honor, no objection. I would note there is no speedy trial waiver on this motion to continue, but looks like speedy trial expires August 16th using the in-custody calculations. So that leaves plenty of time.
Mr.
No
Wood,
objection to that calculation.
Okay, thank you, sir. Hearing no objection from the prosecution, the court will grant that motion. We will set Mr. Martinez's matter over to Friday at 11 a.m. from the Nisqually calendar. I will indicate that there are no change in conditions of release.
Thank you, Your Honor.
Thank you. Mr. Martinez, sir, that is going to conclude your hearing. We will see you back here very shortly, in about 48 hours. We will see you back here, give you some additional time to speak with your attorney, and then we'll conduct your pretrial conferences on Friday, okay?
Can I say something though? Like, well, so it's kind of fucked up, bro. That like,
Sir, I would advise against making any statements on the record. Anything that you can say is being recorded and could be used against you by the city.
No, but I'm saying like it's fucked up how like rich people can do whatever the fuck they want, and then nigga us because we're broke, bro, we gotta do our time, bro. But it's cool, whatever, bro. Fuck the system, bro. That's all I'm saying, bro. I've been here so many times, bro. I'm a hardworking man, bro, and that's some bullshit, bro, for real. Man, fuck the system, bro. I'm out.
Okay, I've signed the order on Mr. Martinez's matter.
Thank you, Your Honor.
All right, good morning. This is the in-custody calendar for June 24th. I assume we have Miss Hauser in custody. Is that correct, Mr. Haverco?
That's correct, Your Honor.
All right, good morning, Miss Hauser.
Good morning, sir.
All right, and Mr. Haverco, I understand you've already been appointed to Miss Hauser. I think Miss Hauser was in court just maybe the last pretrial date or couple weeks before that. So I'll go ahead and reappoint you moving forward.
Thank you, Your Honor. I would say, in light of what the standard for probable cause is, would stipulate probable cause, ask the court to enter not guilty plea only question that sort of entered my mind as I read the probable cause statement is as I understand the facts in the statement, the alleged victim was in their house and just sort of wound up, I think, videoing the defendant who just sort of went out into her yard and started yelling. So, kind of went through my mind as to whether or not that's a violation. But again, it would also stipulate that based on the standard of probable cause, if you hold the evidence, if you view the evidence in the light most favorable to the, non-moving party, it's probably is probable cause. But it looked like essentially she was just yelling out in her yard.
So when I reviewed it, Mr. Ratfield, I guess I'll ask you to chime in on this as well. I understand Mr. Haverco stipulated to it, but she's in her house and there was an allegation she may have been kicking the fence or something like that. It's certainly excessive noise, disturbing the peace at a minimum. It's if the officers that were there sounded like Miss Hauser was directing some of the yelling, at least. I don't know if toward is the correct word, but to some, I mean, it wasn't her singing in the shower.
No, it was, and the city will thoroughly review the circumstances leading to the events recited in the report, but based on Mr. Haverco's stipulation to probable cause,
Right.
city's not going to object to that stipulation.
Okay. All right, fair enough. So Ms. Hauser, we're going to find probable cause purposes hearing only and her plea of not guilty. I'm curious as to what the city's thoughts are on conditions of release.
Pardon me, sir. I'm sorry, sir.
Ms. Hauser, don't say at this point. I've got the attention of the city. I'm just curious as to conditions of release. Mr. Ratfield, are you looking at something?
He just disappeared from the screen.
He may have been having technical issues. I think he's going to log in again and I will promote him again.
Okay. Mr. Ratfield, we got you back?
Yeah, got me back.
Okay.
Sorry, my phone shut off. It got so hot that it turned off,
Okay.
but I'm back.
So I was turning to conditions of release. Thoughts on conditions of release?
Well, a typical violation, I think the city would be asking for bail in the amount of $5,000, but given the actual report in this case, the city's only going to be asking for nominal bail in the amount of $500.
Mr. Haverco?
I would ask that she just remain on her PR because again, the standard is very different for probable cause versus, the merit of the case. But yeah, but I feel that the allegation is so de minimis that, I would just ask that she just be able to return home on her own personal recognizance. I don't feel any bail is really justified.
All right. So, Ms. Hauser, the dilemma we have is this, and I need you not to respond, not to say what did or didn't happen, but I remember you were in court. I think we had a conversation of that time where I said, you're in a boundary line dispute neighbor issue. You cannot direct any actions, comments, anything towards the other side, because what's going to happen is they're going to call the police. And this is what's going to happen because they are a protected party. And I've reviewed the accusations, the allegations, And, the officers indicate that that appeared to be directed at the neighbor. This wasn't just, like I said, I used a stupid example of singing in the shower or a dog barking or birds singing. This was not that. So I think, while I think I've seen a lot worse violations, I still think this is probable cause purposes a violation. If I impose some amount of bail, cash or bond, are you going to be able to post? Mr. Abercrombie, I'm inclined to put it, just because we were just here, I'm inclined to impose $1,000 cash or bond. She would need to come up with $100 and bond. She owns a house, but I'm gonna impose $1,000 cash or bond, just because, Miss Hauser, you have to understand you cannot direct any activity whatsoever towards your neighbor. And if you cannot control that while this is pending, we've got a bigger problem. So obviously comply with no contact orders. Any no contact orders are in place. Let me get into this. Hold on one second. Going to reappoint Mr. Haverco. I'm going to impose $1,000 cash or bond. You're to appear timely at all court hearings. No criminal law violations. Keep your address and everything up to speed. Don't commit any criminal law or criminal traffic violations. And you're going to have to post $1,000 cash or bond. I just don't see how I can not require some additional conditions based on even the circumstances of this situation. So, Mr. Haverco, do we think she's going to be able to post? And you're muted.
Sorry about that.
It's okay.
So Ms. Hauser, without talking about your case at all, please don't make any statements about your case. The court is imposing $1,000 cash or bond, which either means you contact a bonding company, you pay them a fee of $100 and they post a $1,000 bond, or you post $1,000 cash. So I assume as a homeowner, you're likely going to be able to post bond of some kind? We can't hear you. Can you speak up a bit?
I don't think so, sir. I don't have $1,000.
All right, then let's put this on for the July 2nd date, which is next week.
Right.
If she doesn't post, we can deal with her case then. If she does, we can talk about continuing out. But I'm going to leave the bond amount set. And Ms. Hauser, I take no joy in doing this, but you're not leaving me with much of a choice. And I think you're a smart enough lady to understand that no contact means no contact with these folks. Okay. So if you do post, no contact. Otherwise, we'll see you back here on July 2nd. We'll see you back here on July 2nd either way. Okay.
Was your honor going to set on the presumption that she won't bail? Were you going to
Correct.
set the
I'm gonna have
time
it.
at 8:30 or?
Yes, I'm going to basically presuming she's not going to be able to post.
Okay. All right.
All right, I'll sign that order, Ms. Hauser. You'll get a copy of this. I hope you post bail. I hope you're not sitting there for a week. And again, if you've got some friends you could call, maybe you can borrow $1,000 from them so you're not sitting there. But either way, we'll see you here we'll see you here July 2nd at 8:30 a.m.
We can't hear you, Ms. Hauser.
Do we posted now, sir? Posted
What's
now.
that?
Do you need me posted?
And Matt, hold on one second. Madam Clerk, all of the documents for Ms. Hauser just disappeared.
I am doing a new release, or a new order to include all 3 cases for July 2nd.
Okay.
I'm working on that.
Okay. All right. Sorry. Thanks.
Do you need those now to go? Sir, do you need post now to go? Mr. Haverco.
I'll give you a call and talk to you about everything off record when we're out of the hearing. I'll talk to you at a later time when we're not in this hearing right now, because I I don't want you to make any comments right now in front of in front of everybody else with regard to your case. So
Mr. Alvaco.
Yeah.
I have to be at work today, sir.
can I'm assuming the jail has a process where they allow you to contact a local bail bondsman. They can come to the jail. You can sign some paperwork and, 10%, they usually take a 10% fee. So, you'd pay them $100 and they would post the bond. So you should be able to, this is a common procedure with, with bail and being in custody. So you should be able to bond out. You should be able to bond out today.
Is today still Tuesday, sir?
Today is Wednesday at 11:21 a.m. Ms. Hauser, I don't remember. Because I don't want to ask you a lot of personal questions, but I'm assuming, are you a homeowner? Do you own the home? Is that a yes? Okay. Yeah. So I can talk to you later about the case, but again, you should be able to contact a bail bondsman. They should be able to help you.
Okay, so we've got all court dates are going to be, I think, July 2nd at 8:30. Went over the conditions. Abide by all existing no contact orders. $1,000 cash or bond. And all her cases are going to be on for this coming Thursday, Mr. Haverco.
Okay.
All right. So I think what we can do is Sonia, I've got to jump back into another mediation, so I can sign this order. I will sign the order when it's prepared. So I think we can all, Mr. Haverco, if you need to stick on and talk to Ms. Hauser, I'm going to log off. Mr. Raphael, I think you can log off as well.
Okay. Yeah. And I can just talk to her.
Yep.
Once you two log off, that'd be great.
Okay. All right.
Thank you.
And it's ready. It's ready,
All right.
Your Honor.
Okay. Thank you.
Court calls the case of the versus Jason Holdaway.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Holdaway. Mr. Holdaway, state your name for the record, please.
Jason Holdaway.
Here's Claire on behalf. Your Honor, Mr. Holdaway is scheduled before the court today for a violation of probation. Mr. Holdaway is not compliant with the terms ordered by the court in that he is not reporting to probation as directed. He has an outstanding arrearage of $852 on his payment plan. He's failed to complete his outpatient treatment. He's failed to complete the victim's impact panel. And further, Your Honor, I also provided to counsel, I received a report late yesterday from Community Corrections. Mr. Holdaway, since being sentenced, has remained testing on a Soberlink. There has been positive blows on that Soberlink. There was some question because he would report a couple days later and submit to an EPG, which came out as zeros. It's probation stance that Mr. Holdaway is possibly drinking, maybe small amounts, and by the time he's going in for testing, that his body is metabolizing the alcohol that he consumed. I do know, was speaking with counsel late yesterday, and again today, that Mr. Holdaway had indicated that he thought that his reporting to Community Corrections was probation. I can tell you that my office did contact with him, also sending in notification of the violation hearing, which I do give some time for a defendant to get into compliance, and there's been no communication from him back to my office with all attempts. Probation's recommendation, which did not include the drinking offense, the drinking events on the Soberlink, was to remand Mr. Holdaway for 5 days for his violations to date, that probation continue
that he make the payment of the $852 arrears today, then continue with a payment plan of $142 per month, that he report to probation on June 30th at 11 a.m. in person, and that he become compliant with all terms of this court order.
Your Honor, I have had a chance to speak with Mr. Holdaway regarding the, I guess there's two separate issues here, right? The probation issue and then the drinking issue. Regarding the probation, Ms. Pilara is right. He has been reporting weekly to community corrections. He's spoken with Agent Mormon. He said on every Thursday. Yes. He indicated that he thought that was sufficient for probation check-ins reporting. He has been living at the Delana Center for about a year. I don't know, frankly, I don't know what how the mail process there is. I obviously know Ms. Pilara sends letters, and I relayed that to Mr. Holdaway. He indicated he hasn't received any letters, but is willing to continue with his probation. He like I said, he has been testing, I think about almost a year since he started this case. He has been reporting to Agent Mormon. So he's, and when this case was pending before he was sentenced, was very communicative with me. So I think he is able, and again, willing to continue on his probation. I'm just not sure where that breakdown happened. He did complete outpatient treatment prior to this case being authorized. I did provide proof of inpatient to Ms. Pilara. We spoke today, and we both don't have that proof of outpatient, but I'm going to work on getting that from Dawn Farm to Ms. Pilara and to the court. Secondly, the drinking allegations. I spoke to Mr. Holdaway. He denies any drinking allegations. I spoke to Agent Mormon, why he would be blowing numbers and then having these negative ETGs. He says he doesn't know why either, just that obviously something's happening before he's blowing. But
something's happening before he's blowing or before he takes the ETG?
He said I asked, why do you think he's blowing numbers when the ETG is coming back negative? He said he's coming in contact with something with alcohol prior to blowing. The ETG is more sensitive, so I've never seen a situation like this. Typically, the ETGs, come back as positive. And I told Mr. Holdaway, I've never had a situation like this.
When you have low numbers, which these are low numbers on an ETG, what I find interesting, just so that you know where the court's head is at, is had he taken the test the next day, we might have different results.
Can I speak? Sir, good afternoon. I have one kidney, and it takes my body times to siphon through alcohol, if you will. And I don't know how the tests work. I don't technically one or the other, but just I'd put that out there. If I were to blow anything, I'm pretty sure it should show up on a P test.
Not if he waits a day, really 2 days, and then if he is flushing his system, it may not show up.
Okay.
But it seems rather strange because on the 11th, well, let's just go back. January 11th, 2026, he's blowing numbers of 0.02, 0.025, 0.19. They contacted him on the 12th, asked if he consumed alcohol, and they requested an ETG test. And I think the date is important. He reported then on the 13th and submitted to an ETG, which is negative. That 2 days. He then, in February 8th, he blows 022, 021, 018. He denied consuming alcohol again on the 8th, but he reports in to take his ETG test. They requested an ETG test. He reports on the 10th. That also then comes back negative. He's then missing some tests in March, and then in April, he blows on April 14th. He blows a 026, 023, 021, 018, and then comes down to a 0 at 11 a.m. They request an ETG test. He reported on the 15th for an ETG test, but was unable to give a sample. He then came in, and again, we're at that 2-day mark, and they didn't do an ETG test. They ran the wrong test on him on that day. Then May, he then again gets alcohol positive test of a 0.05, 0.028, 0.027, 0.023, 0.015. That was on the 25th. They call him on the 26th for an ETG test. He doesn't report to the 27th. That one comes back negative. From my standpoint, I know exactly what he's doing. In terms of the testing.
Yeah, I think obviously we don't know what would happen if he had reported the next day since he didn't.
Yeah, you're right. He did on one occasion, but then miraculously was unable to give a sample.
I tried. I'm sorry.
And
the guy who was working there, it was 4:15, and I said, I can finally go because I drank 15 cups of water sitting there, and he had already left for the day. So I had to come back the next morning. The next morning, they were out of power when I was there at 9 a.m. So I had to wait until 1 o'clock in the afternoon. It was when we had the tornado that touched down in Ann Arbor. And it was that day. And so I ended up taking it at like noon or something like that when they finally opened it up. But Your Honor, I haven't drank. I had my 18-month anniversary on the 4th. And I'm very proud of that. And I mean, those numbers would say that I had a beer or two. That's not in my nature. To be 15. So, I'm sorry. I don't know why that's blown. Since I was sitting on the bench there, and I mentioned I had one kidney, I have to get blood taken quite often. And the only thing I'm starting to think of is that, I know sometimes when they take an excessive amount, they put something else back in, fluids. If that has something to do with it, I doubt it. I never thought about it before, but I haven't drank. I mean,
say the Soberlink is a breakfast. So it's not like.
The only thing I have to add, Your Honor, is, Mr. Holdaway is appearing at community corrections when he's told to. I think that demonstrates some kind of willingness to be a participant, active participant in the case. He's been blowing for when it doesn't. Since July of last year.
For 1,000 of them.
He's been communicating with Agent Mormon. He comes in when Mr. Mormon tells him to come in. Like I said, I think that does demonstrate from running from this. And I will just add also, Mr. Holdaway was was housed in the last couple of weeks after living at the Delana Center for about a year. So things are stabilizing for him, which I think is good.
What I'm going to do in this case is I'm going to continue to defend its probation in this case. He is to pay that $852 arrearage as arranged at $142 per month. I'll do that, but he's going to have to arrange to start those payments. He is to report to probation. Ms. Valera, Do you have a July 6th time that he could report?
Your Honor, that's not a good date, right? Have the.
Okay, no, that's fine. Any 7? What time? Well, 11 a.m. work. Okay.
And that would be me.
I will indicate that the defendant is to report to probation July 7th, 2026 at 11 a.m. in person. Then he's to report as directed. He's to become compliant with all other previous orders and terms of the court within 30 days from the time of his appearance. I am going to remand the defendant based upon the violations to date at this point. Serve 10 days in the Washtenaw County Jail. When defendant is released, he's to be released, but only after a scram tether is placed. Thank you.
Look at that look. Hey, Judge Simpson. How you doing? Oh, God, you saw me. Ladies and gentlemen. How you doing? How's it going out there? I don't know. Specs was saying that they were angry at Judge Simpson because of some body cam stuff or something. I don't know. I don't know what that means. I don't remember the body cam stuff. I guess I'm sure we watched it. I'm pretty sure I watched it. I see so much court every single day. I'm the wolf that watches the court away. Thank you all for being here today. We do this thing every single day of the week and one day on the weekend. No, I don't remember Specs. I was sitting here trying to rack my brain. I just don't remember. But I mean, that being said, you can't agree with every single ruling that Judge. If you're agreeing with every single ruling that Judge Simpson has, if you're agreeing with every single ruling that any judge has, yeah, they all have their days. That's what appellate courts are for. I enjoy getting their feedback. More than anything, I enjoy watching the process of the court machine at work. You know, you can always expect that you're never going to be in one of these situations, but if you are, here's what happens. It's a cautionary tale of sorts. Join us again tomorrow evening, ladies and gentlemen. Same Wolf time, same Wolf channel. And in the meantime, I have a little tool here that lets me press this little button. And I'm going to hit it. And there's going to be some names scrolling on the screen. And I'm going to say thank you to every single one of you crazy people. I definitely need to come over here and look up my little list and say a special thank you to Wendy Greek. Specs, yada, yada. Ooh, thank you for the support of the channel, my friend. Got Specs, you're on the donation train, and you are appreciated, my friend. And Jamerger, thank you for the couple of dollars there for Wolf's bad word jar when he was in his bender phase in the middle of the stream there. I do apologize for that. Eileen, I especially apologize to you for that. That was uncalled for. Zach, my friend, thank you for coming on by. There is no blow here, but here to blow hard for the machine. Thank you so very much, ladies and gentlemen. I am your Lone Wolf Usul. I find as many of these court cases as I can, and I put them together in these little compilations every single day. And we usually have about 2 hours worth of it to watch. It is an adventure. Hope you come by. Hang out with us again tomorrow and the day after that and this weekend, because God knows I have a ton of stuff for the weekend. I do. It's not even funny. Are the dogs? No. They're there, but you can't see them. Ladies and gentlemen, I am your Lone Wolf Usul, and I am out. Tala semara kapara moros tutukumpa. Unko chopaka untuaka woki. Yeah, it's gibberish. I don't even know what I said. It's funny though, right? Arr! Bye. Oh God, did I clear my throat? Look, I really got to apologize for that last one. I cleared my throat. I thought I had the mic muted when I did it, but I didn't. And Bueller, get in here. Build this. I got nothing left. I'll see y'all later. Bye. Oh, I can't do it that way. We got to do it right. Do it right, chat. Do it right. Do it right. Bye.